Great pleasure to be here, and particularly to talk about cartels and collusion. If I think about the most broadest terms in which to express what is collusion, I would define it as when firms in a market coordinate in some fashion in order to suppress competition. And collusion comes in two varieties. There's explicit collusion, which involves express communication. It's the most egregious variety that you can imagine. And tacit collusion, which is really everything else, all the other ways in which firms might coordinate in order to suppress competition. And we'll be talking about kind of both these forms today. And specifically what I want to cover, and there's kind of two parts to the talk. The first part is to talk about policy, in particular to inform those people who haven't been following collusion and cartels like myself in terms of what's been going on. And it's been a very active area, both on the policy front and on the scholarship front, but I'm going to kind of largely focus on policy. And then I'm going to take on, in the second part of the talk, some legal issues which I've been wrestling with. And while it's somewhat US-centric, I think the issues are really much broader than that. And that the fact is the legal foundations to collusion, I think, are much shakier than what is generally believed. Okay, so let me kind of just briefly go over some policy directions that are in process. And this is where a lot of action is currently taking place and will take place in the future. Screening is kind of provides a bigger role for economists in terms of discovery. Rather than going through leniency applications or customer complaints or the like, the idea here is to look at market data to identify industries worthy of investigation. Okay. This is something which has been used with some success in a number of competition authorities, including Brazil, Mexico, the Netherlands, and South Africa. Though I have to say that when I was first told about success in discovering the shrimp cartel in the Netherlands by a member of the competition authority years back, and I mentioned this to a Dutch economist, he said that there are so many cartels in the Dutch economy, you could randomly choose an industry and you would find a cartel. Now, the only point I want to make here on this is that the presence of leniency programs does not kind of weaken the case for pursuing screening. And if anything, it really strengthens the case. Because leniency programs and screening are very much complements. You think about, why does a firm want to apply for leniency? Well, it's because it's concerned it might be discovered through non-leniency means and it'll have to pay full penalties. Well, screening is something that will enhance the likelihood of being discovered through non-leniency means. Looking at the other way, the thing is, screening is going to identify industries, when it works best, it's just going to identify industries worthy of investigation. It's not going to deliver the evidence that's going to allow, really, for making your case with an administrative or judicial body. But nonetheless, if you have a leniency program, by simply just identifying the industry for investigation, this could induce some, if there is a cartel, some members of the cartels to come forward and apply for leniency. Another program, which is very similar to leniency programs, is the whistleblowers programs, and that has been very slow to be adopted. So this is the idea that to offer rewards to individuals who have information about cartels but are not themselves involved in the cartel. So the two most likely sources of whistleblowers are uninvolved employees at a cartel member and also the industrial buyers who are purchasing from a cartel. And most cartels are dealing with intermediate goods. Korea has been very aggressive in this regard, and has also been good about offering, very high or reasonably high whistleblower rewards, which is really essential if you're going to get uninvolved employees to come forward. Okay. They're apt not to have a career at that company afterwards, even if you have legislation to protect them, and so it's important to provide awards that would kind of induce them to come forward. Interestingly enough, the U.S. Department of Justice, the Antitrust Division, has expressed a lot of skepticism regarding whistleblower programs. I find this kind of curious. Their reason is that it's a threat to witness credibility, and that certainly is the case if you were to use the relator of this information as the primary basis for your case, but there's no reason for that to be true. They can provide information, then you can perform dawn raids, you might get leniency applicants in response to the investigation. So it's a little bit curious that they have been hesitant, particularly since similar programs have been used in the U.S. to uncover government fraud, and they seem to be pretty successful. The private customer damages is another direction that historically has been very important in the U.S. Until recently, in the last 20 years, where government fines have become more significant. Customer damages were the primary corporate penalty in the U.S. They're now being introduced here in the EU. There's a case going on here in Germany on the cement cartel. Let me just kind of mention that and just kind of, for the sake of time, kind of move on. The last one I mentioned is certainly has the greatest potential, but it may be the kind of the slowest to be adopted, which is criminalization. This has been an extremely important tool in the U.S. arsenal, and it's been increasingly used over time, as you can see here on these statistics. We're prior to 2004, we're looking at about a little bit less than half of defendants going to jail. Now it's more around 3/4. And I think it's fair to say that this is the kind of the default position of antitrust division. If they have a cartel case and they get a conviction, people are going to jail. Recently, I guess it was 2004, the maximum sentence was increased to 10 years. There's a recent case this past year, just earlier this year, where the DOJ sought to get the 10-year sentence. They did not. The judge gave 3 years, but they are just very diligent and hard-nosed about putting people in jail. And you can see from this time series that there's going to be an increase in the average sentence somewhere in around 2001, whereas on the order more like a year and a half, to where now it's more on the order of 2.5 to 3 years. In the EU and also throughout the world, there's been an increasing amount of criminalization of price fixing. However, once again, with the exception of the US, it's just basically not used on a routine basis. There's one case in the UK, the marine hoses, but that was only done because it was a global cartel that also involved the US. So they cut a deal whereby they did their jail time in Britain as opposed to the US. So if I look at this kind of table here, this sounds encouraging with increasing criminalization and 3, 5-year maximum sentences, but basically it really isn't being used. So it's still time will tell in terms of whether this will become an important instrument for a lot of competition authorities, but it certainly is encouraging that at least it has become, it is in their toolkit, but now it's just a matter of being able to use it. Okay, now all those cases I just mentioned were all cases of explicit collusion. Clearly these are things that that we want to outlaw. Okay, just was one final kind of example of what I have in mind with explicit collusion. This is again from the Lysine cartel, the FBI tapes. There's Terry Wilson, high-level executive at Archer Daniels Midland. He's sitting on the sofa with another cartel member saying, "They are not my friends," referring to customers. "You're my friend. I want to be closer to you than I am to any customer because you can make us money." Okay. It's clear we want this. This is unlawful. We want this to be unlawful. However, let's consider now this case. So this is the German spectrum auction. Okay. So they're auctioning off 10 blocks of spectrum, simultaneous ascending bid. And one of the rules in the auction is that any bid has to be at least 10% higher as the prevailing bid. You have two important bidders here, Mannesmann and T-Mobile. Mannesmann comes in with initial bids of 20 million Deutsche Mark per megahertz for blocks 1 through 5 and 18.18 million for blocks 6 through 10. Now, why 18.18? Well, if you add 10% to that, you get 20 million. And so the question is, was Mannesmann signaling to T-Mobile that you should come in now, outbid me on blocks 6 through 10 with 20 million. We each walk away with 5 blocks at this nice low price. And that's exactly what happened. Okay. Now, this is tacit collusion, and it's lawful. If instead what had happened was the CEO of Mannesmann picked up the phone, called the CEO of T-Mobile, and said, "Hey, I'll take blocks 1 through 5, you take blocks 6 through 10, we each bid 20 million. They had done that, and had been discovered, they would, found to violate the law. That's unlawful. Of course, the welfare effects are the same. There's nothing new here that I'm saying. But the point here I want to emphasize, and this is dealing with the next topic, in defining the boundaries of unlawful collusion, is where is it we want to draw the line as to what is unlawful or not? It obviously has not been in terms of what's welfare reducing or not. Okay? And here is, we can think of this more broadly. You know, you have firms in industry, they want to coordinate to suppress competition. There's a range of practices they can deploy in order to communicate to achieve that coordination. And you can think there's kind of a tension there. The more kind of effective is the communication, the more direct it is. Excuse me, the more direct is the communication, the more effective it will be in terms of producing coordination, but also the more likely it is to result in prosecution. So here on this figure, you can see on the right-hand side, we have the running low to high, running from the most indirect to the most direct. On the far right, we have the verbal exchange of assurances, like we saw with the lysine cartel. On the far left, we have price signals, such as with the Spectrum auction in Germany, also an important case in the US. And we think of a whole range of practices in between. It could be the unilateral announcement of effectively occlusive strategy, something that was done in the truck rental market in the US. That's the U-Haul case. Or it could be a change in pricing policy, which can coordinate, which I've argued in a paper was done in the turbine generator case. And there's a recent paper that argues it for Italian wholesale petrol. Or it could be advanced price announcements that were done in the airline industry and also a number of other cases, including the Foley case, which is of realtors. So there's a whole range of practices here. And so when you talk about defining the boundaries, the question is, you know, where do we want to draw this line? And I think this is particularly important because, you know, once we get past the verbal exchange of assurances, a lot of these innovations, like leniency programs, haven't had much effect. I mean, those have basically dealt with the most really egregious forms of collusion. But these things are going to become particularly, I think, important methods of collusion in the EU, given the fact that explicit collusion now is really being cracked down upon. There's all sorts of methods for developing a case and prosecuting it and penalizing it. So it'd be natural to think that firms are going to turn to less explicit means. Okay? And so this is what I want to talk about next. And in the second half of the talk. So there's three things I want to go over, subject to Monica kind of preventing me from doing so. The first one is to talk about the current definition of unlawful collusion, and then to provide a bit of a critique of current legal practice. And as I said at the beginning, this is somewhat US-centric, but I really think the issues are really quite broad. And we'll see here that the legal foundations are basically very confused. And then I'm going to just spend a few minutes kind of giving some initial thoughts I have, you know, towards developing kind of a socially optimal definition of unlawful collusion. But keep your expectations extremely low for the last one. So, okay, so how are things defined? If we look at Section 1 of the Sherman Act, it says every contract, combination, or conspiracy in restraint of trade is declared to be illegal. Now, what subsequently has occurred through case law is that it's an agreement to restrain trade that's unlawful. You don't really see the terms contract, combination, or conspiracy anymore. So agreement to restrain trade is what's unlawful. And that term agreement has now since been encompassed within other competition laws that came along later, such as Article 101, saying that it's incompatible with the common market are all agreements between undertakings which have as their object or effect the prevention, restriction, or distortion of competition. Okay. If we let's now look at this kind of definition, what really is an agreement. In the US, there are several key cases defining an agreement as a unity of purpose or a common design and understanding or a meeting of minds. So that's an important term to keep in mind. An agreement requires mutual consent. An agreement is a conscious commitment to a common scheme designed to achieve an unlawful objective. If you look at the EU General Court, it's very much a similar idea. Agreement requires joint intention. There should be a concurrence of wills. So in some unlawful collusion, if you reread these statements, is a mutual understanding among firms to suppress competition. Now, when I look at that, then I want to think about, well, where does communication fit into that? Okay. And communication is obviously very important. And I was wrestling with this question as I become kind of more educated regarding the legal side of collusion as to, well, I was wondering, well, communication, does that really fit into the definition of an unlawful agreement? Or does it really fit into evidentiary standards? And so a year ago last June, I decided to contact a number of legal scholars to get their views on this. And the question was very simple. You know, Is the verbal exchange of assurances between firms evidence of an agreement, or is it in and of itself an agreement? Is it unlawful that we sit across the table and coordinate prices, or is that evidence of an agreement, or evidence of something that's unlawful? So George Hay, who's been involved in some very important cases, said that, I think that the plaintiff in your case would say simply that the exchange constitutes an agreement. Keith Hilton at BU Law School, similar point. A verbal exchange of assurances would constitute an agreement and not merely acts that facilitate an agreement. Bill Page at the University of Florida School of Law, who's been weighing in a lot on these issues recently, says, that is definitely an agreement if by exchange of assurances you mean an exchange of conditional promises about future prices. That's close to the common law definition of a contract. And Bill Kovacic, certainly one of the most important individuals at the nexus of econ and law, and recently, a few years back, stepped down as chairman of the FTC, said, the bell of agreement rings at the moment assurances have been exchanged. This idea borrows heavily, it seems, from ideas developed in contract law. So those four individuals all really say that, yes, when you communicate, you exchange those assurances, you have broken the law. But then when I turn to John Baker, he says, I will assume that the firms have in mind the same terms of coordination when they assure each other that they will implement those terms. Under such circumstances, the exchange of assurances is evidence of an agreement. And Greg Verdin at the U.S. Department of Justice said that the exchange of spoken assurances is very strong evidence of the agreement. It is always possible for either or both parties to say that they did not mean what they said in the exchange, and if the court can be convinced of that, there was no agreement. So here he's really falling upon the fact that the issue is mutual understanding, not the communication itself. So they're taking a very different view on this. But I think the quotation I like best is from Louis Capello at the Harvard School of Law, truly a brilliant scholar, who said, I've wrestled with precisely your question endlessly. I'm firmly of the view that A, all courts and commentators would deem a verbal exchange of assurances as an agreement, B, but they have no consistent definition of agreement and probably couldn't explain why they believe A. Okay. And I have up there, Louis just released this past summer a book, Competition Policy and Price Fixing, which has been very influential to me in terms of a lot of the inconsistencies in the law and trying to develop a more sound foundation. It's I think, the most important contribution to the law and economics of collusion since Richard Posner's book in 1976 on antitrust law. Okay, so here we have these mixed views, and in fact, none of them. Capello is the only one that kind of recognizes that there's kind of differences of views on this. The other ones kind of think that, well, no, this is what it is. In some cases, it is what's unlawful. In other cases, evidence of what's unlawful. And it's not surprising, that there is this kind of confusion, because when you look at the decisions of the U.S. judicial system, they're inconsistent. We saw those statements saying that it's a mutual understanding to suppress competition, meeting of minds, conscious commitment to common scheme, which is unlawful. But if you actually, those are the statements, but you look at actually how they decide cases, what you find is that communication devoid of mutual understanding can be an agreement. Okay? Now this, Greg Verdin argues against this, but the fact is he probably can't find a case to substantiate his position on that. That is, it doesn't make any difference whether or not we ultimately raise prices. Maybe the prices were exactly the same after our communication as beforehand. Doesn't make any difference. You've broken the law. Okay. Looking at the other way, mutual understanding devoid of communication is not an agreement. And the fact is conscious parallelism. The idea that, well, we just kind of understand we shouldn't really undercut each other's prices. It really just wouldn't be profitable. We've had no communication. We just kind of understand this. That is lawful, and in fact, in principle, it's a defense for why your prices are so high. And I've always wanted to use this term from the Yagan language of Tierra del Fuego, the mahilapinatape, which is that look shared between two people that reflects unspoken understanding. Okay. If that leads to inclusive prices, that's lawful, certainly within the U.S. Okay, so this is why I said at the beginning that the foundations to really what's unlawful collusion are really not in very good shape. And where things stand now, I would say, is that there are these two definitions, which Bill Page refers to as subjective and objective. The subjective definition is that an agreement is mutual understanding to restrain trade. Okay? That's what you would get if you actually, kind of look at, the statements and decisions. The objective definition is an agreement. An agreement is communication with the intent to restrain trade. Okay? Bill Page argues that the objective definition is both what's there and what's appropriate. I would say, certainly Lewis Kaplan and I go into the subjective definition category. I think, for the sake of time, I won't go into kind of a critique of these two, but this is kind of where the debate is at, I would say. Monica, how am I doing on time? 15 minutes? Okay. Okay, let me just skip over that. And before going on in my remaining time talking about my kind of initial thoughts about how one might provide a more sound foundation to unlawful collusion, let me talk about a little conundrum that I've developed, which I call the price block conundrum. Imagine you have two competing managers, who just decide that trying to figure out the profit maximizing price is just too hard. And they've heard about these software programs, these price bots, that can learn their way to prices would yield higher profits. Okay, you feed in data on prices and sales and profits and so forth, and it puts out a price. Okay? They don't know how they work, okay, but they independently use these programs, and lo and behold, these things do end up at prices with higher profits because these price bots have evolved to inclusive pricing rules. Okay? Now, is this outcome supra-competitive? Absolutely. Is it collusion as economists define it? Kind of putting this issue about how do we have the methods to determine whether or not there's collusion as we define it in game theory? And the answer is yes. I mean, the fact is we could determine that for sure. We could look at the code, and we could see right in that code the inclusive pricing rules that they've settled upon. But this would fall under neither the objective nor the subjective definition. There's no communication. Okay, so it doesn't violate the objective definition of unlawful collusion, of an unlawful agreement. And there's no mutual understanding. The managers don't know what's going on. They just put the programs in place and let them run. So unless you want to get into kind of deep philosophical issues about whether or not software programs can understand, this is going to be lawful as well. Okay. So all that kind of example is to point out is that there's still things to be thought through about how we kind of define kind of unlawful collusion. Okay, so now what I want to do is, in terms of thinking about this, I just want to kind of use the game theoretic framework. I'm not going to build a particular model. I'm just going to use the general framework to kind of try to think through how one might define unlawful collusion. And I should say I'm not the first one to do this. There's a nice paper by Susan DeSanti and Dennis Yao who looked at this. Greg Verdon has done a piece. Lewis Kaplan has done some. I have a few original touches here, but it's something which other people have sought to do. Now you think about, just in terms of starting with, why is there competition law regarding collusion? Suppose you had a market where individual firm profit maximization, and resulting in equilibrium, result in a unique outcome. Okay, we just call it here the competitive outcome, but it's just a unique outcome. As a society, we decide we either like that outcome or not. If we don't like it, we have to regulate. The role for competition policy and role for on prohibiting collusion has to do with the fact that there's multiple equilibria. Yes, there's one in which, okay, firms achieve a static Nash equilibrium, which we usually think of as a competitive outcome. But then there's other dynamic equilibria, which sustain higher prices through the threat of some punishment if a firm undercuts that price. Okay. And obviously, firms want to try to get to those equilibria with higher prices, but of course, lower welfare. And competition policy is all about trying to keep them away from it. Okay. So that's the way I kind of think about it, is that we want to design competition law, once again, with regards to collusion, to keep firms away from the kind of lower welfare equilibria. So let me just, as a way to start kind of organizing my thoughts, and that's all that I've accomplished thus far. Think about 3 desiderata for a law prohibiting collusion. One, obviously, is that it's beneficial. That is, if you implement it right, it's going to raise welfare. A second is that it's implementable in 2 senses. First, that it's a law whereby it's reasonable for firms to know when they are violating the law. Okay? And secondly, that it's reasonable for the government to know when the law has been violated. Okay. And the third one, which I think is new, is what I have to come up with a better term, but right now I'm calling equilibrium consistent. That is, we don't want to put in place a law whereby all equilibria are unlawful. Who knows what's going to happen there afterwards? So there needs to be that safe harbor for a firm, that there's an equilibrium. That is the implication of individual firm profit maximization and correct beliefs, which is actually lawful. So now we think about applying this at different levels. We could think about a law which makes outcomes unlawful. We could think about a law that makes strategy profiles or equilibria unlawful, and a law which makes changes or movements in strategy profiles unlawful. So let me first dispense with the outcomes, a law that makes outcomes unlawful. Because if you think about writing that down, it's going to be something of the form, it is unlawful to set excessive prices. And there obviously are excessive pricing laws, and they're distinct from, we think of them as distinct from competition law. Some of the ones I've seen are very poorly defined, and to me they just fail on implementation. How is a firm to know when they're pricing excessively? I mean, we do have laws talking about, for example, I think in the US, a fair and reasonable price, but that's in a regulatory context. And they know when they're having a fair and reasonable price because they have to put their price before a regulatory body who tells them. But that's not the case here. So I just don't think excessive pricing laws make much sense. So what about have a strategy profile be unlawful? Well, we think about kind of the canonical inclusive strategy profile, where we're going to support some price above the static natural equilibrium price, and we're going to do that through the device that if any firm sets a lower price, we're going to go to some sort of lower price equilibrium. Okay? That's going to result in lower profits, certainly for that firm that deviated. Okay, so there's that threat of a punishment, the threat that the future path is punitive, that's going to sustain that higher price. Now, when you look at the U.S. Supreme Court decisions, they seem to be, if you take them literally, they seem to be talking about exactly that. A conscious commitment to a common scheme designed to achieve an unlawful objective. I mean, that's kind of sounding like a collusive equilibrium. But of course, we know that's not the case because they also require evidence on communication. Okay? But a literal reading of some of their decisions really suggests that it kind of sounds like a collusive equilibrium. So here we could think about his proposal. It's unlawful for firms to use the threat of a future punitive response to influence current prices. Okay, that would be a candidate for outlawing certain strategies. That certainly takes care of this price spot conundrum, because that would then be unlawful. It does have parallels, I think, to the legal interpretation of predation, which, of course, is not a great parallel because, predation, the law regarding predation has seen very few kind of successes. But I think you could phrase predation as it's unlawful to threaten future aggressive pricing if a rival firm does not exit. And here it would be, it is unlawful to threaten future aggressive pricing if a rival firm does not set a high price. Okay? Now, the thing that would be curious about this is that the threat could be to go to something lawful, which would just be a static natural equilibrium. Okay, so let's just kind of play this through and ask ourselves, well, is this implementable? Would firms know when they're violating the law, if that is the law? If it's, it's the threat of a future punitive response to influence current prices is what's unlawful. Certainly when we write down the theories, we think we would answer that yes. I don't know whether it's always so conscious among the firms of this punitive response. They might not have expressly articulated it, but it probably would satisfy that. Obviously, from a practical perspective, there's the issue of, well, going to the other leg of the implementation condition, which is, well, can the government determine when the law has been violated? And that obviously deals with the challenges within I.O. of empirical methods for determining the type of equilibrium. And that's clearly a formidable obstacle, but obviously it's dependent, it's something that can change over time, okay, with the state of the science. But the point I want to make here is I'm not convinced that such a law is equilibrium consistent. That is, if you wrote that down as prohibiting strategies which use its punitive response, I'm not sure that every market would have a lawful equilibrium. And I mean, here's a simple example that people are aware of. Just consider a price gain with homogeneous goods, constant marginal cost. We know the static natural equilibrium is price equal to marginal cost. But now you throw in a per period fixed cost, Well, in that case, price equal to marginal cost is below average cost, so that's not going to be an equilibrium. And in fact, the only equilibria with multiple firms in the market is going to entail firms pricing at or above average cost, and that can only be sustained through this type of punitive, threatened punitive response. So this would be an example where there'd be a problem here, in that there's no equilibrium that's really lawful. There's another case here which, let me kind of skip. In fact, maybe I have, how am I in time now? 5 minutes? Okay. Yeah, actually, let me go over this. There's another case, which this one I'm not so certain about, but because it just depended upon what has been characterized, not what we know exists, which is if we go back to a classic article by Eric Maskin and Sean Tirole, which looked at not the standard infinitely repeated game, for which a lot of the thinking related to collusion is based upon, but rather it was an environment where firms take turns choosing prices. So when one firm chooses its price, the other firm is locked into its price. And they characterize a Markov perfect equilibrium in that situation, and one for which there's a stationary outcome. And that Markov perfect equilibrium is of the form shown here, and let me just show it kind of graphically. So this is what the strategy looks like, where so what we show here is a firm's optimal price given the price that the other firm is charged. That's locked into. This results in a steady state price of P star. And what this rule implies is the following, that if the other firm was to set a lower price, as shown here, the response of this firm would be to drop price all the way down to P lower bar. The response of the other firm in response to that would be to raise price back up to P star. And so, they weren't out to characterize collusive equilibria, but this is really all they found in terms of just Markov perfect equilibria, which we think of as kind of the analog to non-collusive equilibria. Well, all they found here was something which looks very punitive. I mean, it looks exactly like a collusive pricing rule. And it just kind of comes out of the structure of the environment. Okay, so the last one possibility here is that what we make unlawful is a change in the strategy profile. Okay, rather than make a strategy unlawful, we make a change in the strategy profile unlawful. And so here you can think about, well, just like we go back to that figure, firms are moving from one kind of equilibrium outcome, one equilibrium to another, and going from low prices to high prices. The nice thing about this is, in a reasonably well-defined way, it refers to coordinated behavior. It was always a bit odd that people would refer to coordinated behavior for dynamic equilibria, sustaining super-competitive prices. Equilibria or equilibria, whether they sustain super-competitive prices or not, they're all unilaterally optimal. But here, in terms of moving between strategy profiles, we can think of that, well, yeah, that's a coordinated move, that all firms are changing their strategies. It certainly seems implementable. I think it's fair to say firms would be consciously engaging in this act to change their pricing rules. And it certainly is equilibrium consistent, because every equilibrium is lawful. It's the movement between equilibria, so to speak, that would be unlawful. Now, where will this lead? I'm not sure. There is a bit of a logical conundrum that was raised when DeSantis and Yao originally raised this point of possibility, which is it meaningful to change your strategy? Okay. Now, this is getting kind of a bit philosophical, but I think it is pertinent. And when you think about trying to write down a sound definition, if we have firms have always priced at the competitive level up to period T-1, we might think it's kind of natural to expect they would price at the competitive level come period T. But the fact is, that behavior is fully consistent with a strategy whereby they price at the competitive level in period T, or they price at the monopoly level in period T. Okay? And it's consistent with many strategies. And in what sense can we say that a strategy has been changed if we see that a monopoly price as opposed to the competitive price? And this idea of whether it's meaningful to it's well-defined to change your strategy I was concerned with for quite some time. But then I kind of realized that this is actually just a common paradox in induction, and it's referred to as Goodman's paradox. And the fact is, one has to wrestle with this in any sort of circumstances. And if you kind of are at a loss and you don't know where to go, you bring out a quotation from a famous philosopher, Wittgenstein is hard to beat. And here the best guide would be that to use as, you think about induction as accepting as true the simplest law that we can reconcile with our experience. And that might be the guide to determining to what extent was a strategy changed.